under revision in Muslim law. I'm going to take preemption, that is Arabically known as Shufa. In Kannada it is known as Purva Krayadhikara. Purva Krayadhikara. Preemption. And after that one I will go to apostasy and conversion and its legal effect. And finally I will read today polygamy and mutha marriage. So coming to the preemption. What is preemption? What are the essentials of the doctrine of preemption? Who can preempt? And what are the slight differences exist between the Sunnis, Shias and the other classes, subclasses, even with the Hindus? Customarily, there is every possibility of following the preemption. So first, let's have an introduction to the preemption. The right of preemption, Purva Kraya Adhikara. Kraya, say, Adhikara, power. Power or right to sale or power to either purchase immovable properties, and prior to that there are certain rules. Both the buyer as well as owner has to follow here under land laws. So this is the preemption. So introduction. The right of preemption is a right to acquire by compulsory purchase. This word you must know. The right of preemption is a right to acquire by compulsory purchase of immovable property in preference to all other person. The object of preemption is the prevent the introduction of a stranger among co-sharer. What does that mean? I will give you an example. That is, A and B are the co-owners. A and B are the co-owners. Illustration, I may say. It is an illustration. A and B are the co-owner of an immovable property. A, he wants to sell immovable property. Okay. So A wants to sell this one to unknown fellow, C. A sell his share of property to the C instead of selling to the B, who is very closer to him by many manner. So instead of selling to this B, this fellow will sell this one to C. Here, by means of the right of preemption, B can call upon C. B, by the right of this preemption, B can call upon C and compel C to sell the property. And compel the C to sell the property to this B owner. He would have sold and this transaction would have stopped. But here, A purposely sell his portion of immovable property to C, save a stranger, and later A thinks that everything is over, but due to the preemption power, right of preemption, B is having every power to consult the C and make him to obey or accept that he should again sell the immovable property of A to this fellow only. This is the right. This is not a coercion or force or any political influence being placed here. So it is one of the rule existing in the Indian land law. So preemption. So for preemption, main ingredients to be, see, what are the essential elements? What are the ingredients? That is, preemption is a right which the owner of a certain immovable property possesses to obtain property's possession of certain other immovable property which are not of his own. First one. Second, the right, simply I may say, preemption is a right which is available to the owner of an immovable property. Preemption is the right which is available to the owner of an immovable property. Always you have to make this one a stressed point. Second one, the right is obtained in substitution for the buyers. The right is obtained in substitution for the buyer who has already purchased that other movable property. So under this right, the owner of an immovable property claim his substitution in place of the buyer of an immovable property which is adjacent to the property of claimant. Here claimant is nothing but a preemptor. So coming to the third point, the right of proprietary possession. The right of proprietary possession is obtained on the same terms on which that other immovable property is sold to the purchaser. This is very important. The right of proprietary possession is obtained on the same term on which that other immovable property is sold to the purchaser. To say it simply, the claimant of the right is entitled to repurchase that adjacent property, say immovable property only, at the same price and at the same condition on which it was purchased by the buyer. How we will purchase? Not on compulsion or force or coercion, but he has to pay the existing market price and also the other terms and condition which he had followed. That should be followed by the B. Then he can take this one under preemption even after lapse of years and years. The right of preemption is in the form of special privilege which is available for quiet enjoyment of an immovable property. Okay, this is the very important. And next one being a proprietary right, it can be enforced against any purchaser, irrespective of religion, caste, and creed. That is, the right is given by law for the quiet enjoyment of the property. Here, the thing is, if an unknown person takes the adjoining immovable property of this fellow, he will sell and he will go away. But for the fellow who is persisting there, resisting there, he is there forever. So the combination of AB is always good Whereas CB, it doesn't hold good. So in order to curtail all the disparities, problems, disputes, so it is better to have the immovable property with a known personality or with the one who is even today present in that location. That is important. That is ground for justification. I want to say this. So, however, it is not looking to be a kind of justifiable. But however, under this, it is already been justified. Preemption, that right is there. And it is not only available for Muslim. Any person, irrespective of religion, caste, creed, if he possesses immovable property and next to him any portion, part is there, that immovable property can be purchased by that fellow owing to the conditions which are prevailing in the market and other terms and conditions which have been laid out by the seller. In that way, this preemption is one of the very important. So, ground for justification. What are the ground? The hardship and inconveniences of a joint owner. Now, since beginning they are very close. Yes, everything is moving very nicely. But when this fellow goes away and this fellow comes here, then eruption of anything may happen on illegal matter or on illegal ground. So, that hardship and inconvenience of a joint owner would be greater than those of a stranger vendee. And in having his as his participator, it may happen that he may be required to abandon the property. So it is the case. If this fellow comes here and C and P cannot adjust even for the forthcoming days, so inevitably if he is strong enough, then this weak fellow has to move away from the portion. So whether it will occur voluntarily or involuntarily, it's a different issue. So for adjustment at part 2 AB, the C and B cannot adjust. So in order to make the environment suitable, feasible and comfortable, yes, well, they must, C and B must be again a combined personality, or the C must give up his immovable property which has been purchased very recently to the B only, so that B will make use of the whole land and he will be in happy mood without any hindrance from the legal view. The second point here is, first one is hardship and inconveniences. Second one is democratic conception underlying the Muslim law of inheritance. Democratic conception underlying the Muslim law of inheritance tends to disintegrate the family property, and the law of the preemption considerably mitigate the evil. So it is good. If both were happen to be a Muslim and this fellow is a non-Muslim, then non-Muslim and Muslim, no, they never correlate with anything of that one. So at that condition, if this fellow being a Muslim, if he owns from this fellow the new Gandhi, so if he owns the whole of the immovable property, yes, it will be convenient. In this way, everything should go. Even he should prefer the fellow who is coming to purchase this land must be very cooperative, coordinate to him, and probably mostly another Muslim will only come and he will do it. In that way, those fellows who are closer to him and in a harmonious way they may live, so that fellow will be preferred by the person who is already occupying this one. So, who can preempt? After this one, so this fellow is ready to sell, but to preempt, what are the conditions? Who can preempt? So this preempting, this one differs from when? Sunni law, The right of preemption can be available for the following person according to the Sunni law. What are they? Yes, you know, the co-sharer in the property. Co-sharer in the property. Co-sharer in the property. Shafi is Sharik. That is known as. Co-sharer in the property, Shafi, Shufa or Shafi in Sharik. Second one, a participator in the immunity and appendages of the property. A participator in the immunities and appendages of the property. That is, a participator in the right of a way or a right to discharge with a what? Khalid. Shafi. First one is Shafi Sharik. Sharik or Sharik. This is the co-sharer. So those who distribute participator in the immunity and appendages of the property and who distribute road, bridge, water. So Shafi Khalid. Participator. Sharer. Okay. Next. A neighbor or the owner of adjoining immovable property. Neighbor. Shafi Zar. Co-sharer will become Shari, participator will become Khali, and neighbor who is there, to him only again. This A did not give, but he must have given. So okay, B now, yes, if you want to sell, yes, he will sell to the fellow who is there next to him. That is neighbor. But under Shia, the right of preemption is available only in case where there are only two co-sharers in the property. This is in Sunni, whereas in Shia, co-sharer must be there. Co-sharer must be there. Right of preemption is available to only a co-sharer or only in case where there are only two co-sharers. In Shia, among two co-sharers only it is available. Shafi class you know. With the co-sharer as well as co-owner also it is available. That is Shafi school. Okay, you need to. So, cases in which the right of preemption arises. This is most important. The cases in which the preemption rights, when does the rights arises? It arises in cases of sale. It arises when the sale is complete. This is very important. Only in case of sale, when both are doing their own agricultural this one, nothing will happen. Yesterday's feature will never disturb them. Only when they are about to sell. So, only in case of sale, the right of claiming preemption is applicable. Such sale must be valid, bona fide, and mere intention to sell can never be a sale. Mere intention. Oh, during Diwali I am going to sell. During Ugad. No, that doesn't come here. Sale includes exchange, but not gift, waqf, bequest, inheritance, and any other, say, lease of perpetuity, mortgage through by conditional sale and conditional sale. These are the cases where the preemption doesn't arise. For the mere sale, yes, it is okay, but conditional sale, it doesn't. So, it also includes gift, waqf, bequest, inheritance, lease in perpetuity, and mortgage, though by conditional sale or conditional sale, all put together. this is the area where preemption does not happen. For giving gift, no preemption. You can give gift. But while going for sale only, and that too, this preemption will exist. If there is a mutual understanding, preemption doesn't arise. Preemption arises to the neighborhood only when this fellow has already sold his immovable property. That is only on completion of the sale. The right of preemption arises and not before that one. So on payment of purchase of money and possession of property, the sale is considered to be complete. The execution of the instrument of sale is not needed. According to the Muslim, however, it is very good that TP must be there, and to denote that TP, yes, registration must be there. But the Supreme Court of India held in Radha Krishna Lakshmi Narayan versus Sridhar that where the transfer of property applies, the transfer should be as under the provision of the TP Act, and Muslim law or any other law cannot override the statutes. Thus, preemption is applicable only as soon as the title has been passed. So, coming to the requirements. What are the requirements it need? Coming to the requirements. Of preemption. First one. Coming to the requirement. The preempter, the fellow who is going to observe. So the preempter should be the owner of the immovable property. Preempter should be the owner of immovable property. And since we are dealing with Muslim property only, so, and basically there is one ground level law is there. The Muslim property must go to Muslim only. Muslim property must go to Muslim only. That is helping to uphold the Preemption Act. So he should be a Muslim. Here in this semester 2, going through the Muslim law, that to the preemption portion, we have to insist that parties must be Muslim. The sale must be done by some other owner. Okay. Fourth one, the buyer need not be a Muslim, but in Bombay and Calcutta High Court, the buyer should also be a Muslim. So there are, owing to the locality, tradition, cultural influences. So they do. All preemption will be between Muslim only because yes, they have adopted this system. And owing to the system only, they are carrying out this one. And even there are certain courts like Bombay, Calcutta and other courts which have also influenced that preemption shall have to take place between the Muslim community only. The demand of preemption should be made. So only on demand or to the decree of the court only that could be possible. So in my one special class I have given the constitutional validity of preemption. That I have given. Article 14, 15, 16 and 19. Article 14, 15, 16 and 19 that helps in upholding the constitutional validity of the right of preemption. That you can refer that video. So procedure for claiming the preemption. This is most important. Procedure for claiming preemption. The right of preemption is an interference. Right of preemption is an interference with another's right to sell his own property, and the person trying to enforce his right of preemption must make 3 demands. What are they? Immediate demands, confirmatory demands, demand for possession. So the person trying to enforce his right of preemption must make three demands. One is immediate demand. That is talab-e-mawasibat. Talab-e-mawasibat is immediate demand. He must do. Or else the sale procedure will not take place. And again second one is confirmatory demand. That is talab-e-ishhad. Third one is demand for possession is talab-e-tamlik. These are the Arabic terms you need not to worry about. But however, three demands for claiming preemption are there. One is immediate one is confirmatory one, and another third one is demanding for possession. So what is immediate demand? What is immediate demand? The moment the news of sale comes to the person, he should make an immediate move and demand at that very moment whether they are witnesses or not. With fellows he may go or without. He may go alone, and he must contact the real owner of the next immovable property and put forth his intention of buying that one. So this method of demand is called demand by jumping. You must show eagerness to accept that one. So there should not be a lapse of time, and the demand must be made promptly. Intention must be there. Intuition of accepting that one must be there. And more than promptness must be there. So the immediate demand must be made after the sale is complete and not prior to its completion. And according to the Transfer of TP Act, the sale is complete only on registration, and the demand may be made either in person or by an authorized agent or with any witnesses or representative, or even with a letter, that is letter written form, that is all. Generally, if there are two or more buyers at the same day or at the same time, two or more buyers come to the immovable property owner who is adjacent to them. So the preemptor need not mention the name of all the purchaser in the demand. Okay. Next one is confirmatory demand. The demand of jumping, that is first one, is followed by a formal demand affirming the preemptor's right. So in the presence of at least two witnesses, specially called for that purposes, he must go along with the witnesses only and see that every transaction shall take place immediately and more effectively and with confirmation. It is sufficient to just declare his readiness to pay the price, and he did not tender payment immediately. Partial payment, advance payment, in that way it will go, okay, because everything is based on mutual understanding. The affection of giving, that plays more, and intention of taking, acceptance, each plays the vital role. So every transaction lawfully is very easy. When there is intervene and interruption of any unlawful or any unjustifiable or any chaotic manner, that will create the problem, and this will lead to disputes. Or else all transaction on humanitarian ground with give and take policy, yes, it is of the supreme nature. So confirmatory demand and to the immediate demand, yes. Now, sooner to the completion of these two, he must be eager enough to possess this one. How you will possess the more property of next fellow or other person? Only by taking its ownership. Purchasing is nothing but taking its ownership. And how that ownership will be denoted? This will be denoted by the change of title. How this title will be changed? This will be title changed lawfully by the registration, because any property or anything, article worth of 100 rupees or so must be registered under Stamp Duty Act of India. So now demand for possession must be there. Even if it occurs between the relatives, brothers, uncles, everything, if you have paid amount, if you want to intend to be the owner of the next portion of the property, yes, it is your primary duty, judicial duty, to see that the document must be in your name. And that could be made only by the making the registration of that property in your name. This is very important because it will guard you, it will safeguard you even in future. Throughout your life and even to the after your life, while going for partition among the successors, yes, it will be a good document. So, demand for possession, this is the institution of suit within the limitation period prescribed by the Limitation Act. Yes, one must go. That too. This is the very serious issue, and one must see that it should be completed. So where the right of preemption is lost, I have already told you the preemption doesn't apply in the case of gift, waqf, bequesting, inheritance, lease in perpetuity, mortgage, though by conditional sale or conditional sale. At this juncture there is no preemption. And again, where the right of preemption is lost, it will go away. How? First, the death, you must write like this. Death of preemptor during the pendency of the suit for preemption extinguishes the right of preemption in the case of a Sunila, but in Shiala, the suit may be carried on by the heirs of the deceased preemptor. When the sale process is not completed, it is about to complete or in the halfway, then if he dies, the giver, giving person or the real owner, or old owner, former owners dies, yes, everything will come to cease. This is under Sunila. But Shiala says, even to this status quo, any of the heir of the preemptor can follow the procedure and see that all the steps should be completed. So under the Indian Succession Act, the suit may be continued by the executor or administration. If among the relatives or the present representative of the family of the preemptor does not able to or competent enough to carry out this one, so then court may appoint either the executor or the administrator, and he can perform all the pending procedure. The right is not extinguished by the death of the preemptor. In that case, right will not be existed. Instead of legal heir, the executor or the administrator who is being appointed by the court will look into. Second one is very important. Acquiescence. ACQUIE, yes, CENCE. What do you mean by this one? Acquiescence. Okay, acquiescence. If the preemptor either by taking the lease of the same property, if the preemptor either taking the lease of the same property from the purchaser or by the failure to make demand, he is deemed to have acquiesced in the sale and thus loses his right to preempt. When he leaves due to acquiescence. What is acquiescence? If the preemptor either by taking the lease of the same property from the purchaser or by the failure to make demand, he is deemed to have acquiesced in the sale and thus loses his right to preemption. So because of that only demand for possession must go ahead. So third one, if in the suit for preemption, if in the suit for preemption, preemptor joins another person as co-plaintiff, but the co-plaintiff has no right to preempt, then the right for preemption lost. Fourth one. If the preemptor transfers the immovable property, if the preemptor transfers the immovable property, which is the subject matter of preemption, then he loses the right to preempt. Even on complete transfer procedure, it's transferred already, so no preemption right is there for you. So, fifth one, waiver. W-A-I-V-E-R, waiver. What is waiver? By entering into a compromise with the purchaser, if the preemptor waive his right of preemption, collaterally if he waive, yes, then also he loses the preemption right. Sixth one, failure to make demand. If the preemptor fails to make the immediate demand and confirmatory demand, since he is not having any possession, then he loses the right of preemption. Seventh one, last being this one, is if the preemptor releases his right for consideration, if he is able to voluntarily release his right of preemption, then also he will right. So this is important. Constitutional validity. Second one, the occasion where the right of preemption is lost. Third one, who can be preempt. And lastly, the essential element of preemption. These all four are the important part. To support this preemption, there happen to be supporting special enactments are there. What are they? Under special enactments, the law of preemption is applicable to Muslim as well as to non-Muslim of the area. Where such elements are in force, special acts which regulate the law of preemption are Punjab Preemption Act of 1913 is there, Agra Preemption Act of 1922 and Oudh Law Act of 1876, Bhopal Preemption Act of 1934, Rajasthan Preemption Act of 1966. These are all few special enactments which even today in vogue, in effect, and they are in one way or the other way helping the Preemption Act to be in its position, that too being recognized under the constitutional validity. So for constitutional validity only, I have given the very exact picture in my previous classes. You please refer that particular portion, you will come to understand. So for that again I would like to say, a decision of the Supreme Court under Bishan Singh versus Khazan Singh, AIR, 1958, Supreme Court, 838. A decision of Supreme Court was referred to in which the question of rival claim put forward on behalf of the two adjoining owner was discussed, and their lordship laid down the following propositions. What are the proposition? To know the fact, and factum is very important. The right of preemption is not a right to the thing sold, but a right to offer a thing about to be sold. The right of a preemption is not a right to the thing sold, but a right to offer a thing about to be sold. This right is called the primary or inherent right. Second point is, the preemptor has a secondary right or a remedial right to follow the thing sold. Third one, it is a right of substitution, not of repurchases. That is, the preemptor takes the entire bargain, steps into the shoe of the original purchaser. Thereon, he will take the right of preemption. So it is a right to acquire whole of the property sold. Fifth one, preference being the essence of the right. Preference being the essence of the right, the plaintiff must have a superior right to that of the vendee or the person substituted in the place. Sixth one, the right being a very weak right, it can be defeated by all the legitimate method, such as the vendee allowing the claimant of a superior or equal right being substituted in his place. So these are the very recent decision and observation. Not only observation, it is the true decision made by the Lordship of Supreme Court.